All right, good morning, everyone, and welcome. I am Leanne Bosch. I am a partner and shareholder with the firm. I'm joined by my partners, Richard DeBoest and John Trebilcock. We are a full-service law firm with 5 offices across Florida, perhaps most well-known for our large community association law practice. I have been asked to moderate today, so please bear with my scratchy throat and sniffling here. I apologize. We are here for our 2025 legal updates, and we are going to be discussing the most relevant changes to the Florida statutes in 2025 as they pertain to condos, cooperative associations, and HOAs. Please note that if you are in an HOA, there were no changes to Chapter 720 for HOAs in 2025. So what we are going to be doing is a refresher of the 2024 changes for HOAs. And we are expecting to be here about 2 hours today, so please plan to be sitting down here for 2 hours. Quick disclaimer, our presentation is not legal advice and should not be considered legal advice. We are expressing our personal opinions here today, and we are offering this presentation for informational and educational purposes only. Please always rely on your own attorney to address any specific legal questions that you or your community may have. This course is approved for credit for both directors and community association managers. After you attend today, all attendees are going to receive a certificate by email within 24 hours. If you are a CAM, however, we do need you to email us. So if you are a CAM, please email us with your name and your CAM license number so that you can receive your credits. And the email address we would like you to use is webinar@gadclaw.com. I will post it in the chat so that everyone will have access to it. Again, if you're a director, no need to do anything. If you are a CAM, I need you to email us with your name and your CAM license number. You should have all received a copy of the materials that we're discussing today. I do have them up on the screen, but please feel free to pull them up on your end if they're a little small on the presentation. I will also post them in the chat just in case you did not receive them. We do plan to make a recording of this course available on our website so you can go back and refer to it. And we are going to take some questions along the way today, but most questions are likely going to be handled at the end of the presentation. I would ask that you please use the Q&A box for questions. We have a very large audience today, so we cannot unmute anyone to speak. If we don't get to your question today, please feel free to contact us. We may be able to get back to you. Otherwise, we sometimes use questions for our newspaper articles. Richard is going to kick us off today. Thank you for attending, and I hope you enjoy.
Thank you, Leanne. First of all, as far as the credit goes, for condominium directors, this will satisfy your annual 1-hour continuing legal education requirement, okay? For HOAs, your continuing legal education requirement is 4 hours if you're in an HOA that has fewer than 2,500 homes, and you're required to take 8 hours if you are in an HOA with 2,500 or more homes. This is a 2-hour course. So for the HOA directors, this will satisfy 2 of your 4-hour requirement. For cooperative directors, there actually is no CLE annual requirement. This is not a board certification course, which is a different course required for new directors that are appointed or elected to the board. They have to take a different 4-hour course called a board certification course. That course is also currently available on our website to view at your leisure, and you will get a certificate. So if you're a new director, you do need to take the course you're taking today, but you also need to take that one-off special board certification course. And if you haven't done that, you can reach us, outside of today. We can help you do that, or go to our website and you can find it. We're going to start off with the changes to the Condominium Act, Chapter 718. So these do not pertain to cooperative or HOAs. Then we're going to roll into a little bit of 719, which is the Cooperative Act. And then, as Leanne mentioned, there is a section on the 2024 changes for Chapter 720, which is pretty robust. There was nothing done in 25, but in 24, they did focus a lot on Chapter 720. So there is quite a bit that you have. So While you're an HOA director, just suffer through a little bit of this, and then we'll get to you as well. So to start off with, the first part is this first section for Chapter 718 only applies to condominiums and cooperatives. This is also a cooperative section for the milestone or SERS reserves, and that applies to condominium or cooperative buildings that are 3 stories or more in height. This all came out of the Surfside disaster of several years ago. SERS reserves are structural integrity reserve study, and the milestone study is required for buildings when they reach the age of 25 or 30 years. So if you're in a low-rise condominium or co-op of less than 3 stories, what I'm going to talk about in the next few minutes does not pertain to you. If you're in an HOA, none of this pertains to you, but we'll roll through this pretty quick. Number 1, a milestone study is now only required for buildings with 3 or more habitable stories in height. Formerly, it just said 3 or more stories. So the first issue that came up when these laws came about several years ago was, what if our condominium or co-op building is 3 stories, but story number 1 is under building parking? So there's really only units that we live in on floors 2 and 3. Do we still have to do the study? And under the old law, the answer was yes. Now they've clarified it. It's habitable stories. So if you are in a building that's 3 stories or more, but you only have 2 of those stories in which there are residential living units, you are not required to do the milestone study. So this was a clarification that was a good change. Number 2, in the milestone study disclosure, and the milestone study is the study that must be done after 25 or 30 years, depending on your municipality's requirements, to basically do a review of the building to make sure it's still structurally sound. So if you're a new building, you don't have to do a milestone study, but if you've reached the age of 25 or 30 years, you will have to do it if you fall into the category. But what this says now is that if an architect, the study must be done by an architect or engineer. If the architect or engineer that is performing the study also intends to bid on the work that the study might dictate that you perform, the architect or engineer must disclose that I intend to bid on the work that I'm also performing the study on. I suppose this is designed to be kind of a conflict of interest disclosure. If I'm preparing the study that says what work needs to be done, and I'm also going to bid on the job to get paid to repair the work, there's a bit of a self-interest there to potentially, I suppose, put more into the study that's necessary. I don't think that really happens with reputable
I
engineers.
think, Richard, it's not just where obviously I'm doing the study and then I'm going to do the work. It's also relatives, because if you notice,
Yes,
there's any interest directly, indirectly, where it may not be obvious to you that
right.
that there's a relationship there.
Good point. I mean, if the engineering company might have a sister company that is a general contractor, which a lot of them do, they need to tell you, hey, we're going to bid on it as well, so that you know everything's on the up and up in the front. So that's good. Number 3, on or before December 31, 2025, and every year thereafter, the local enforcement agency is required to provide the department with information regarding how many buildings have done the milestone study, et cetera, et cetera. This does not really concern you too much. It's the local municipality that oversees the studies.
But it'll only concern our clients if they go down and actually pull permits themselves, and it'll explain why the building officials are so grumpy that this unfunded mandate was passed down from Tallahassee to our local officials.
Right. Number 4 here is actually probably I guess, depending on your point of view, a good change. The problem when the SERS reserve study requirements came out, which are the structural integrity reserves, I mean, that required you to save a lot of money in a lot more reserve categories for many, many years. So you're just socking money away to replace significant parts of the building, maybe in 20 or 30 years. And, you get low interest rates, on those deposits and things. So now the statute has been amended to say you can fund your SERS reserves in the normal way, which you collect the money every year over the lifespan of the item. But now, on a majority vote of the total voting interest of the owners, you can choose to fund your SERS reserves with a special assessment, a line of credit, or a loan that is immediately available at the time it's needed. What this really allows you to do is not actually pull the money out of your owner's pockets year after year after year, but have a line of credit available that might be available in 20 years that you would then be able to use to fund the repairs required or the replacements required for the SERS reserves, etc. Sounds like a good idea for the people today, but the people in 20 or 30 years that are there, they're the ones that are going to get a special assessment to pay back that loan. So it's really, in my mind, kind of kicking the can down the road. But for those of us here today, it does allow, an easier way to fund it. I only know of a couple communities that have done this. It's kind of brand new. A lot of banks don't have programs yet available. But if you're interested in that, you should take a look with your banker and your local council. Number 5,
But Richard, before we move on, I think one thing we didn't touch on there is you need that majority of the total voting interest to take out the loan for the reserves. But that's just for the reserves. For the actual work that may have to be done, that's called for in the milestone reserves, you do not have to get that vote to actually do the work.
Right.
To take out a loan, special assessment, etc.
Number 5.
Sorry to interrupt again. We do have a question. Is there a cost to having a loan open?
Now that's the tricky part.
The interest.
Yeah, the bank, and this is an important analysis. If you're going to have a line of credit that's not going to be tapped for 10, 15, 20 years, the bank isn't going to let that hang out there with not making some money on it. So yeah, there is a cost to doing this, and you may want to look to see if we're paying the carrying costs for all those years, how does that weigh against actually just collecting our own money and putting it in a higher interest bearing account? And it may, so it may not be the best way to do it. That's an analysis, an important analysis that you'd want to look, but there's definitely will be a cost.
To me, the public policy behind this really doesn't make a lot of sense. The whole point was to stop kicking the can down the road and make people fund their reserves. So now, instead of allowing you to just waive the reserves and do a special assessment interest-free later, we're allowing you to use these loan vehicles year after year to kick it down, and there's going to be interest and other costs. So I think this was political pressure. As we know, the cost of insurance and assessments, the politicians needed an out to say they did something. Whether it's really the best way, every community has their own needs.
Right. Number 5, this basically says that if, God forbid, we get another hurricane or natural disaster that makes the building uninhabitable, you can suspend the collection of, the board may pause funding of the reserves. There's no reason to collect reserves to replace a roof in 20 years when the roof is gone due to the hurricane and you're going to be replacing it in a year. So this would allow you to suspend. You used to require a vote of the owners to suspend. Now the board can suspend. But again, I think all of us would prefer the alternative of never having to invoke this authority, because it means your building is in bad shape if it's uninhabitable. Number 6, for a budget adopted on or before December 31, 2028, if the association has completed the milestone inspection within the previous 2 years, with approval of a majority of the total voting interest, the association may temporarily pause the reserve funding contributions required to fund the milestone study repairs. The point of this is, if you have a milestone study that says you need to fix X, Y, and Z, and you also have a SERS reserve study that says you need to replace the same X, Y, and Z in 20 years, why would you fund the reserves when you already have to do the work under the milestone? So you can pause funding of the SERS and use that money to make the necessary repairs under the milestone study and then restart the SERS later. But I do think you will need another SERS reserve study.
Yeah, after you pause either under 5 for uninhabitable building or to do the work called for by a milestone, you have to go get a brand new SERS, because obviously the old SERS would be based on facts that are no longer relevant.
Right. Number 7, quickly, SERS reserves are not required for a building with 4 or fewer units or with less than 3 or fewer habitable stories. This just aligns the SERS exceptions with the milestone exceptions, because they're essentially the same thing, but the exceptions were different. So in the old law, you might have to do a milestone study and not collect SERS, or vice versa. Now, if you're accepted under the milestone, you're accepted under the SERS. So really just that. Number 8, The former law says that the SERS reserve study was due by December 31, 2024. Now it says it's due by December 31, 2025. It just kind of allowed you an extra year to do the SERS reserve study. Frankly, if you were required to do it under the old law and you missed the date, you were violating the law. But now with this, you're not violating the law. So if you haven't already done your SERS reserve study, and remember, this is for buildings 3 or more habitable stories and more than 4 units, you have to do a SERS reserve study, and this time it's due at the end of this year as opposed to the end of last year. The next one is number 9. If an association completes a milestone inspection, they may delay completing the SERS reserve study for 2 years. Same thing as kind of the prior law. You can delay funding so that you can perform the repairs required under the milestone. Now, the final thing, and then we're going to get into things that are relative to all condominiums, not just the 3 stories or more. The final one is now when you get your SERS reserve study, an officer or director of the association must sign an affidavit acknowledging receipt of the SERS reserve study. And then under the current law, you must also publish that SERS reserve study on your website, give it to potential buyers, and let the state know that you got it. This is really designed to say you can't claim ignorance of, I didn't know I had to do all that. I didn't know I have the study. One of the officers or directors will have to swear under oath an affidavit that says, I got it. And that prevents any shenanigans about, I didn't know I got it and I didn't disclose it properly.
Yeah, and don't forget those SERS don't just come to the association. They also send them to your building officials. So,
right.
Yeah, don't try to hide the ball.
Yeah.
Quick interruption here about the materials. We're getting a lot of questions about the materials. You should have received them by email. I have also posted them in the chat box, not the Q&A box. Please look under the chat box for them. If you still are not able to get them, please email us and we will be happy to send them to you.
Okay, number 1's kind of a technical change, and then I'm going to let John jump in on one of his favorite topics, is the video conference laws, which are really kind of affecting everyone. Very quickly, number 1 here, there was an exception in the prior statute that if you were a multi-condominium with 25 or more condominiums, which is a very large multi-condominium association, a multi-condominium association is one association, one board of directors that administers and governs more than one legally distinct condominium. That's called a multi-condominium. If you were 25 or more condominiums administered by one board of directors, you were allowed to use alternative funding methods approved by the state rather than actually funding the reserves directly. Now, any multi-condominium can do it. So if you are a multi-condominium association, there is an opportunity. And alternative funding is different than what we talked about earlier about having a line of credit or a loan. So if you fall into that category, talk to your legal counsel. There may be a way to delay funding of the reserves altogether. It's kind of an exception, and kind of technical, but it is out there. And I'll let John kick off from here for a little while and go from there.
So video conferencing, this is one that has stirred the pot with a lot of associations, because now if you're using Zoom or a similar platform, those meetings have to be recorded, and those recordings become an official record of the association. Number 2 is the definition of video conference. It's found in the definitional part of the statute, and then throughout the statute they make references to the new rules that they put in place for video conferencing. The definition of video conference becomes important. It means real-time audio and video. So Zoom, what we're doing now, you have audio, you have video. Does that mean that just calling in on the telephone is a video conference? It doesn't really meet the definition. We'll talk about that a little later in point 11, how that comes into play. But one thing that everyone needs to be aware of is if you're going to have a video conference meeting, a hybrid meeting, you have to, number 1, put the hyperlink and call-in conference number on the notice. That'll be a violation if you forget the link and the phone number if there's a way to call in. And this has always been the law and always been our advice to clients, but they've clarified it to make it clear for those of you who would push back against us. You have to have a physical location. for this meeting. If somebody does not want to participate via Teams, Zoom, etc., they have the right to go to the meeting and sit and observe and participate at the in-person meeting. Now, these have to be recorded again. They have to be recorded and maintained as an official record. And as we'll talk about again a little later, you'll have to keep these on the website if you are required to have a website for 1 year. And you'll have to keep them for 7 years unless you have approved minutes for the meeting. If you have approved minutes for the recorded meeting, then you can take it and delete it after 1 year.
Let's talk about the possible exception because it's video and audio enabled. That's always the catch here.
Yeah, we're going to go over that down in number 11, but as good a time as any.
Sorry.
So again, whenever you look at this definition, video conference means real-time audio and video. The statute later says that board meetings can be conducted, number one, in person, or number two, by video conference. Well, so is just a telephone good enough? Our opinion as of now is yes. But the big caveat here is, and you'll see this as a theme through a lot of the update, is that the legislature's directed the division, the DBPR, to promulgate rules to further elaborate on this. So if you call in, just like in the old days, pre-COVID perhaps, before Zoom became a thing, you just have a speakerphone and people could call in and the members could come and sit and listen to the meeting. We think that's probably still permissible because if you look at the statute, it literally says, right after it says it can be in person or video conference, that directors can call in and their attendance can be count towards a quorum if they're just on the phone. So the statute, they added some things that they didn't necessarily modify other parts. So some of it, we'll see how it shakes out. But Richard, would you agree that for now?
Yeah. So the practical effect of this is, we always advise against recording the full meeting, okay? And either audio or video and keeping it as a record because insurance companies and others that are trying to find things to use against the association will scour those 4 or 5 pages of every word said and find things, take them out of context and try to use them against the association. So we've always advised against it. The new law says if it's a video conference, you have to record the meeting and keep it. So the question is, well, what if we just audio record? Okay. Do you still have to record the meeting? And currently our interpretation is no, you don't have to record the meeting and keep it if it's just audio enabled, not video and audio enabled. So the question we get is, well, what if we use Zoom, but we don't use the video portion? It's just audio. Under the current interpretation, you would not have to record that meeting. As John mentioned, that very well could change because the division's going to make rules and we'll see where they come out on their rulemaking. But right now, if you just have audio only with people coming in and only listening and speaking on audio, you do not have to record the meeting and keep it. So that's.
However, I will warn you, if you do that, the reaction from your owners often is going to be apoplectic. Yeah. So
it's been very difficult to implement because they believe the board is not being transparent. And I've had to go to meetings and explain the board is actually trying to protect you from things said that are kept forever that the insurance company will use. Well, this guy said the roof on the clubhouse was bad 3 years ago. Well, he was a guy from the audience that doesn't know what he's talking about, but they'll glom onto that and say, well, you were aware that the roof was bad and now you're making an insurance claim and you didn't fix the roof. That's the risk of recording every word said at a meeting that comes back to bite you later.
Right. And well, 2 points on that note. Don't forget the owners can still record it themselves. So even
video and audio
even if you take that path, the owners can still record it. And 2, I don't want to overstate, in my opinion, I really do think the division will promulgate rules saying that the legislative intent is transparency, and they may say you can't do that. They haven't done it yet. But if they do it in the next few months, don't say Richard and John and Leanne said this, and now suddenly they're saying something different because.
Yeah, and keep in mind, this law is pretty well known and everybody confuses it. I get questions from HOAs under Chapter 720 about this. This does not apply to Chapter 720 HOAs. So you can video conference. You do not have to record the meeting. None of that applies.
Yeah,
We
it does
just
not
had a
apply to
question about
HOAs
that.
yet, but next year I suspect that the legislature will. They seem to have this ping pong effect. They'll do one thing to 720 HOAs one year and then put it into the Condo Act the next year, and so on and so on.
So to answer that question, this discussion is pertaining to condos, not HOAs.
Correct. If you see 718 on this screen, it only applies to condominiums. That's the Condominium Act.
There's a question here about how residents would participate in a meeting like that. And the answer is, we have to have that capacity enabled for them to be able to speak.
Well, that's an interesting glitch. Goes back to that definition John said, video conference, video and audio. If you have a video and audio enabled video conference meeting, the owners must be allowed to attend, just like the board. But if you have audio enabled only, I believe my reading is it doesn't require the owners to also be allowed to attend on the audio portion. Again, trying to implement that will be, challenged by owners. But the old days, you would have a speakerphone and only the board would appear on the speakerphone, and you did not allow owners to also dial in on the speakerphone. They had to physically attend the meeting. In my interpretation, that is still allowed if it's an audio enabled only board meeting, but good luck, because the owners are addicted, rightfully so, to the convenience of Zoom and things like that.
One more question here. Do either of the statutes stipulate where, if you're having a board meeting in person, do either of the statutes stipulate where the meeting has to take place?
I believe it says it's within the board meeting. I believe the annual meeting has to be within 45 miles of the community, or
well,
50.
they changed the annual meeting for condos.
Yeah, they changed it.
15 miles or the same county. If it's not the annual meeting, I don't think they changed it for whatever reason.
No.
It still needs to be 45 miles for the same county.
You want me to keep going, John, or you want to pick one?
Well, management contracts. So management company, they have to have all this common sense. They need to have all the licenses that Chapter 468 requires them to. What's new here is there's now an affirmative duty on all directors to make sure that your manager, your CAM, or your management company have all the licenses that they're supposed to have. If they don't, you can terminate the contract. Or if they're suspended during dependency of that contract, it can be terminated or voided by the association.
Okay, property insurance coverage. This is Chapter 718. You used to formally have to get an insurance value, a property appraisal every 36 months. They now changed it to every 3 years. I'm not sure the significance of that change, because 36 months is 3 years, according to my math. Then they also changed some of the verbiage about full replacement value. They changed it from shall to may. No one's really sure what the significance of that is. And our opinion is, if you're in a condominium, you still have to insure the building for full replacement value.
And you can base that on the appraisal that's done has to be done every 3 years if you're doing it that way. Same thing, like Richard just said.
Number 5 is John. You want to go ahead, John?
Yeah, sure. Minutes of the committee meetings. So there are 2 types of official records that you have to keep. There's certain records that have to be kept forever, like minutes, the declaration, things like that. This is making clear that minutes of committee meetings also have to be added to official records. Now, which committees, some attorneys have different views, whether that means all committees, and some have the view, Richard, you have the view of which
the statutory committees, which are a committee that works on for condominiums, a committee that works on the budget, a committee that has final authority to expend money on behalf of the association. Those are statutory committees.
Right. Some other attorneys read it as all committees means all committees. So
which would mean the minutes of the social committee or the flower planting committee, which is kind of absurd.
It is, but this does make clear that the video recordings of board meetings, member meetings, your annual meetings, special member meetings, and committee meetings are official records, and you have to keep them for 1 year, assuming that you have approved minutes for those meetings. Again, if you don't have approved minutes, I believe you have to keep them for 7 years. So make sure that you have those minutes to show that when you delete it, you had that deletion was done legally. Also, it makes clear accounting records that are official records, includes the bank statements and ledgers. So more emphasis on transparency, especially in financial matters, coming from the legislature. They deleted the word repeatedly for directors and board members and CAMs that willfully, knowingly, or intentionally deny access to records. That could be a misdemeanor if you're doing it intentionally. The word repeatedly was removed, but it is still in at 720. So those of you in the HOA world, you still have the word repeatedly, and that's defined as twice. But in the condo world, it is one time could be a potential misdemeanor if you're doing it willfully, knowingly, or intentionally. Official records on the website. So document that's required to be on the website, and there are some official records that must be on the website that are defined in the statute. If it is one of those, you have to make that change within 30 days after it's received or created, unless a shorter period is otherwise required by your documents or another part of the statute specifically. Board meetings minutes for the past 12 months have to be on the website. Video recordings or a hyperlink, which is probably more likely, have to be on the website for 12 months, not 12 years, 12 months must be on the website. Financial reporting. So this was a good change that they, Leanne, this was a good change. Within 180 days after the end of the fiscal year, the association must send the year-end financial report to all the owners, or just send a notice that it's available upon request. Last year, when they drafted the statute, I believe mistakenly said "and," which makes no sense that you would send the actual report and a notice that they can inspect the report. So they changed that to "or." And they actually did do us a favor here, because now you have 180 days to do this, where previously you had 120. So, and once again, another thing you'll see, there are a lot more affidavits that are required to be sworn out. Here, an affidavit must be executed by an officer or director confirming compliance, and that affidavit's an official record that must be maintained as well. Another change, and this is another theme, where all 50% plus one of all owners can waive the year-end financial report requirement. It used to be just those present and voting. And Richard, my memory is failing me here. You can only do that every year.
Yeah, under a law from last year, for condos, HOAs, and co-ops, you can only waive down your statutorily required year-end financial report every other year now. You used to be able to waive it out every year, but now you can only waive down every other year. So if you have to do an audit, you can waive it down to something less, but next year, if you're required to do the audit based on your revenue, you've got to do the audit. So you can only waive every other year.
So question here, I love this question because we deal with this all the time, but it's not an easy question to answer. What happens if your accountant is late with the financials?
If it happens once, you'll very likely, and somebody reports you to the division, you'll get a educational letter, typically just saying you did it wrong, don't do it this again. If you do it more than once, you will get a financial penalty. But with the extension to 180 days, there really should be, the excuse before was the 120 days fell right around April 15th, which is tax season, as we all unfortunately know. And that's why a lot of CPAs were overwhelmed and delayed. So now they have 6 months. So if your CPA can't get it done in 6 months, depending on that you gave them all the proper records, which is often not the case, then, you know, maybe there's a problem with your CPA. But if everything's in order, they should be able to get it done in 180 days.
Okay, number 10 is another example where I think the legislature is trying to do a good thing, but maybe cause more confusion. So we've always believed that boards needed to make best efforts to make prudent investment decisions by relying on qualified third-party advisors. But the legislature decided to codify that, and they said that associations may invest reserve funds in certificates of deposits or a combination of these, CDs, with savings, commercial banks, savings loans, credit unions, without a vote of the owner. When I say they may have inadvertently created a problem, they didn't add the magic phrase including but not limited to. So when they listed these investment vehicles as permissible vehicles, did they exclude others like treasury bills? Last time I checked, treasury bills, United States treasury bills, are still one of the safest investment vehicles you can have, but they didn't put it in the statute. My advice has been, if that's what you're doing, you continue to do it. But there is
Yeah, this was a topic of discussion at last week's big condominium conference over in Dana Beach, where all the condo attorneys were there. The other part that was discussed was this without a vote of the owners. You can invest it in these listed items without a vote of the owners. It doesn't say to invest in other things like treasury bills, you need a vote of the owners, but that's kind of implied. If you can do this without a vote of the owners, if you want to do something different, do you need a vote of the owners? And what is the vote? And there was a fairly healthy split of opinion on leading attorneys about what do you need the vote? I kind of take the attitude that you could do it before without a vote of the owners. And I still think you can put it in, fiscally conservative treasury bills without a vote of the owners, but that's debatable, and we'll see where that comes out.
Yeah. Number 11 is what we were discussing earlier, video conference board meetings. This fleshes it out a little more. You can have in person or by video conference. Again, the division is going to promulgate rules to flesh this out further, and it's an official record. Now, member meetings. This is another one that's causing some angst as we approach annual meeting time. So the annual meeting now needs to be within 15 miles of the property or the same county. But the big thing here is if you have a hybrid video conference annual meeting, the law requires that a quorum of the board be physically present at the annual meeting. This shows that sometimes the legislature is comparing apples and oranges, and they don't really understand the difference between a board meeting of the board and an annual meeting, which is a members meeting. And the board members are only in attendance in their capacity as a member of the association, not as the board. I think we've speculated as to why they did this. Richard, do you want to share your theory?
This didn't really come up at the condo committee meeting, but I suspect this is because, owners went to their legislators and said, we don't know who our board is. We never get to see our board. They hide behind video conferencing and they don't let us talk. And we don't get to point our fingers directly in their face and scream at them and tell them how horrible they are in person. So you need to make them come to the annual meeting so that we can, berate them in person. I mean, that's the only logical reason it's not logical, but that's the where some of these laws come from is owners that legislators don't really understand what's going on. And then you get a law like this. The other thing that I think, what happens if the board says, no, we're not physically coming to the annual meeting. It's not
the statute doesn't lay out any penalties. It doesn't say what will happen. The good news is, though, the only real business that has to happen during the annual meeting is the election. And as long as 20% of the eligible voters vote, the election is valid anyway. And there's nothing else that couldn't happen at another special members meeting where this law doesn't kick in and require a quorum of the board to be there to waive reserves or reporting requirements or to roll over funds or the other kind of housekeeping things that often happen at annual meeting. They can happen at another special members meeting.
Right. I'll take 13. This is another kind of scratch your head. Sounds like a good idea, but I don't know, law. The former condominium law said if the board adopts a budget greater than 115%, which means 15% more than last year's annual budget, then within 21 days of the adoption of that budget, the owners on a 10% petition could petition the board and hold a special members meeting and force through their own budget. That's been the law for, I don't know, 25, 30 years. In all my 32 years of doing this, I had the members exercise this right maybe 2 or 3 times, and they never passed their budget, okay? Because they usually missed the 21-day mark or whatever. But it was out there as a check and balance on a board, maybe adopting a budget that was unrealistic. So it was not a bad law, and it was there. Now what the law says is if the board adopts a budget greater than 15% more than last year's budget with certain exclusions, and you have to go to your attorney and determine if the 15% calculation applies, because it's not a straight calculation. But if it does apply, then in addition to the board's budget, the board now must also propose an alternate budget that is below the 15% cap. And then they must present that budget, both those budgets, at the board budget adoption meeting. And here again, as John mentioned, the legislatures don't understand the difference between board meetings and members meetings. So the board at its board meeting where it's going to adopt its budget must now present the alternate budget, and then the members can vote at that meeting to force through the alternate budget. But again, it's not a members meeting. Board members don't vote at board meetings. So you're going to have to hold a hybrid meeting, I suspect. So, the thing is, make sure you really have to follow this law if you've increased your budget, because there are exclusions. But if you do, you now have to present both budgets. The only saving grace is, I believe, the budget adopted by the members is by a majority of the total voting interest, which will be very difficult to obtain. So I don't really think you need to worry about this too much. But if you fall into this category, just keep in mind you now have to have 2 budgets, one above where you want it and one below, and the owners get to pick.
And one thing just to clarify, because some people sometimes try to push back about what that 115% means. That doesn't mean if your budget is $100,000, just for illustrative purposes, that it has to be $215,000 for that to trigger. It's 15%.
Right.
So sometimes people question us on that.
Number 14, there's always been in the law that in addition to painting, paving, and roofing reserves, you had to reserve for any capital item that cost $10,000 or more to replace. A good example would be a pool or an elevator. They now, after 30 years, have realized that there's inflation, and they've increased the $10,000 threshold to $25,000, which will also be adjusted for inflation. So it will increase every year. So now, if you have an item that was $15,000 to replace, you would have formerly had to have a reserve for that item. You no longer have to do that. It's $25,000 or more. So you've got a little more flexibility.
Yeah,
the next one,
your non-serves structures.
Right. Yes. Number 15 was also a topic of significant discussion at this year's condo cluster development meeting. It says an association's reserves may be pooled. SERV's reserves may also be pooled only with SERVs, and no owner vote is required to move to pooled funding of reserves. Okay, which means the board can decide to go to pooled funding. Nobody disagrees that that's what this law means. Where the disagreement is, what about the already existing segregated non-pooled reserves? Does this law now allow you to move those pre-existing reserves into the newly created pool on a board vote, or do you need an owner vote? Formally, we would tell you needed an owner vote. Due to this new law, there is a bit of a difference of opinion. I'm of the opinion that you can move your existing segregated reserves into the newly created pool on a board vote. But other very experienced and well-respected attorneys believe you still need an owner vote to move. So again, not sure how this is going to shake out. But if you didn't do it the right way that the division ultimately determines you should, I don't think you're going to get in trouble as long as you follow their advice once they give it. They have not opined on what they believe this to mean. Number 16, hurricane protection. Last year's law for condominiums said if an owner has installed, let's take an example, hurricane shutters on their lanai, and the board has to have the hurricane shutters removed from the lanai so that the board can perform necessary maintenance on, let's say, the lanai slab or something. The law from 2024 said the association must pay to have them removed and must pay to put them back, and it's a common expense. Well, a lot of governing documents already said if this is an owner responsibility. So now the law says, if the governing documents provide that the owners must pay to have them removed and replaced if the association has to do necessary work, that's valid. But if your documents are silent and the association has to remove the hurricane protection, the law says you're going to have to pay to take it down and put it back up. So if your documents require that under the association's responsibility, you may want to consider amending your documents to say otherwise, or confirm that your documents are the way you want them to be. Electronic voting, this is probably a good change in the law. And again, this is condo only. They didn't change this for HOAs, although the electronic voting law is exactly the same. Formally, to adopt electronic voting, the board had to hold a special board meeting with 14 days mailed and posted notice. Now you can hold a regular board meeting, 48-hour single posted notice, and the board can adopt electronic voting. So it's a lot easier to adopt electronic voting. Additionally, if a board refuses to adopt electronic voting, they simply don't want to do it. Now the law says if 25% of the voting interest petition the board to adopt electronic voting, they have to do it. So this is a law designed to encourage electronic voting, which I believe is in the end, a good thing. It saves trees, it saves time, it saves money, it saves mailing problems and voting
Saves
errors.
manager burnout.
Right.
It's just
The
it's
next
easier
one.
it's
Yeah.
easier to monitor, easier to check for fraud. It's more fluid. So I think they're really trying to push people in that direction, and it makes sense.
Now, number 18, is going to be real interesting. And again, the intent of this law is to encourage you to go to electronic voting. They want you to use electronic voting, okay? But if you do not have electronic voting, and this is the law as of July 1, so this is going to apply to your upcoming condo elections. And if you haven't adopted electronic voting, pay close attention. You may well want to go out and adopt electronic voting, because if you do not offer electronic voting, which means I can go to a website, I can put in a PIN number, up comes the ballot, I can check the boxes, I can hit send or submit, and I have now voted. Okay, I don't have to vote in paper, I don't have to do all of that. If you do not offer electronic voting, you now must offer email voting to the owners who choose to give up their secrecy or anonymity right, which means you're going to have to establish and probably a dedicated email address. You're going to have to make sure people get the email that says you can now vote, by returning your ballot basically via email if you give up voluntarily your right to secret ballots. And there has to be a big disclaimer on there that says, I know I'm giving up my right to a secret ballot, which means everybody will be able to see how you voted for the directors, and you can no longer tell your golf buddy who lost the election, but I voted for you, because if you voted this way, they're going to know that you didn't. In any case, my opinion is this is going to be extremely chaotic, because you will now have three methods. You'll have a different method of voting. I can see people saying, well, the election was at 6 p.m. I sent my ballot, my email back at 5:45 p.m., but due to the internet delay, you didn't get it till 6:30 and the election was over, and I'm going to challenge the election. And I can just see all kinds of chaos caused by internet delays and things. So I would advise you strongly, don't be the test case on how you do email voting. Let others figure that out, and maybe in a year or two, you want to do it, but consider moving to electronic voting.
I have a question about how much electronic voting costs to set up, and I don't have the answer, but most of my clients tell me that it is very cost effective. I don't know if you guys know.
I think I've heard numbers $1,000 or less for as many votes as you want to do during the year. Now, for a large association, that's not a lot. For a 30-unit condo, maybe that's cost prohibitive. But again, the savings in mailing, time, messed up ballots, I think it's well worth it. emergency powers, they changed the emergency power law. It used to be you could invoke them when there was a mandatory evacuation of your local area. Now it's if it's even a voluntary evacuation ordered by the state or the municipality, your electronic or your emergency powers are now in play. Number 20, developer-made contracts. This applies to commercial condominiums. If a commercial condominium turns over, they can void a pre-existing developer-made contract on a 75% of the voting interest. This is similar to the long-existing law for residential condominiums that says after turnover, a residential condominium can cancel a developer-made contract on a 75% vote of the owners. So it's just moving that into the commercial condo area. Number 21, non-condominium portions of buildings. This doesn't apply to, it says within 60 days after the fiscal year, and the owner of any portion of a building that is not subject to the condominium form of ownership, but for which the association does contribute. So like you might have a commercial component on the bottom, and the residential condos have to contribute to that commercial component that's not actually part of the condominium. That commercial component still has to provide you a financial report of the cost that you're contributing to, and you have the right to
Could be
challenge
like
it.
shared parking
Yeah,
levels,
exactly.
clubhouses, like Richard was saying, there could be stores, but you share elevators, lots of
Exactly.
different type of things that could come into play.
Number 22, if you haven't done this, the deadline's already passed. October 1, 2025. There is a whole laundry list of things that you're should have, and if not, you need to do this. This is really applies to each association must create an online account with the condominium division and input all this information: the mailing address, the email and telephone address, the name of each director, contact information for the manager, so on and so forth. This is really what John likes to talk about: the government passing on its former obligation, passing it down to the association to make you do all this instead of them having to do it.
And a lot
So,
of it they already have.
right.
You already have all of this on your SunBiz. You've already turned it in on your annual updates, but you know,
Number 23, formerly for many, many years, when you bought a residential condominium unit in Florida, I contracted to buy a residential condominium unit. There was a 3-day cooling off period, which meant I could come back in 2 days and say, I went home and my spouse said, no, no way, we're not buying that condo. You better go back and cancel that contract. And you can cancel that. And if you ever watch the movie Glengarry Glen Ross, there's a famous scene with Al Pacino similar to this, where the spouse said, you bought how many flooded lots in Florida without looking at them? And anyway, I'm straying. What they've done here, the cooling off period is now 7 days. And as Joe Adams, who some of you may know, said at the condominium conference, which he thought was a funny line, and I think it is, and I'm going to steal it from him. In Florida, there's a 3-day cooling off period to buy a handgun. Okay. Well, I think buying a condominium unit is so risky, they've now changed that cooling off period from 3 days to 7 days. So you have a longer cooling off period in Florida to buy a condominium unit than you do a handgun, which, it's kind of interesting. Finally, the MySafe Florida condominium program was instituted to allow condominiums that want to harden their building with hurricane protection, windows, doors, or roofs. You can now get matching funds from the state of Florida up to, I believe, $150,000 or more. It may be more. Bottom line is, if you're going to put on a new hurricane-rated roof, windows, or doors in your condominium as the association, you can get a vote of the owners, which used to be 100%, it's now 75%. And if you qualify, you can get matching funds from the state. So if you're thinking about doing these types of projects, think about the MySafe Florida condominium program. Talk to your legal counsel. You may be eligible for the funds.
just remember that is not retroactive. So all the work you have already done for Ian, et cetera, you can't get reimbursed for that. This is prospectively, and it is still just a trial pilot program. But they found that it was so onerous that all the money they put into it wasn't spent. In fact, nowhere near it, all of it. But so they tried to make it a little easier, but it's still quite a lot of hurdles. But
And finally, for condominiums, number 25, Flood disclosure. This is for a developer. The developer of a residential condominium must disclose to a prospective purchaser in conspicuous all cap type that the owner's policy, the owners in a condominium typically have what's called an HO6 policy that is not flood insurance. It doesn't cover flood insurance. So this is designed to make sure the consumer, when they're buying a condominium, is aware that they're not covered for flood insurance unless they buy their own separate flood insurance policy or unless the condominium already has flood insurance. So it's kind of a consumer protection idea. Cooperatives, all that changed in 2025. Some of what we talked about previously has just been incorporated into Chapter 719. Not everything for condos that we talked about, just some of it. I'm not going to go through it because it's the same thing for certain things about investing funds, reserves, pooling reserves, emergency powers, reporting to the division, all rescission period, and flood disclosures. Those same exact laws, but not all of them have been put into 719. So there's no reason to go through them again. The next part here, I'm going to let maybe John kick this off because I need a drink of water. But this is the part that Leanne mentioned up front. There were no changes to Chapter 720 in 2025, zero. But there were significant changes in 2024. So for those of you that might have fell asleep for the last hour, this is now Chapter 720. And it is the actual 2024 changes, but they are very relevant. And I'll let John, unless Leanne has some questions.
A quick interruption. I think we get this question every webinar. Now might be a good time to address it. What is the difference between a condo and an HOA? And, the answer is condos are governed by Chapter 718. HOAs are governed by Chapter 720. You can almost always tell the difference by looking at your governing documents, but the nuts and bolts of it is it's the form of ownership. So condominiums are owned, they have common elements that are jointly owned by all the owners together. And HOAs, you typically are owning just your lot underneath your house or the footprint of your house, the land and the house. So it's really how title to the property is held. That's the legal answer. But for your purposes, what you need to know is whether you're governed by 718 or 720.
Yeah, the typical question, we get a new client and I say, are you a condo or an HOA? They say we're townhomes or we're coach homes. And townhomes and coach homes are developer sales descriptions of the product. And it does not, you could be a coach home HOA, you could be a coach home condo. So you really have to look at the documents, and the governing documents should refer to 718 or 720. But it's a critical question because while the laws are very similar in certain respects, they're very different in other respects. And that's the critical first question. Are you a condo or HOA? Or maybe you're a co-op under 719.
Right. Any other questions to address now, or?
Go ahead, John. We'll save the remainder.
Okay. All right. So HOA, the first item here already went to effect. Obviously, at the beginning of the year, if you have 100 or more parcels in your homeowner association, you must establish a website and post certain records there, accessible to owners in an owner portal. Inspection of records. We already know that there are official records and owners have the right to inspect and make copies. But there are now criminal penalties if you intentionally refuse to allow inspection. You potentially could be subject to a misdemeanor crime. That doesn't mean the state attorneys are out there looking to crack down on any innocent mistake. I think that it would have to be pretty obvious before there would be criminal penalties. But this is something to be aware of. We need to, you have 10, in an HOA, you have 10 business days to respond to a request to inspect and copy the documents. So you need to, be timely and make sure that that is responded to and an opportunity is provided to those owners. Few more items here about intentionally destroying accounting records in order to that's not just a misdemeanor. It's a misdemeanor to the first degree. So these are a little more serious, but you can get a felony of the third degree down here on F If you willfully or knowingly refuse to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime. Now, look, this is in 720. This was already illegal. Covering up documents in furtherance of a crime is a crime. But I guess they figured they put it in here just to make it a super duper crime, so to speak. Subpoena for records. If you get a subpoena from law enforcement, you need to cooperate. You provide a copy of those records, make those records available for inspection to the law enforcement agency. If you get a subpoena like this, I think your first call should be to your association attorney. Usually we can get an extension because, 5 business days may be a very tight deadline, and for whatever reason, maybe you wouldn't be able to comply, but it's important to try to get an extension if that is the case. So if you get a subpoena from a law enforcement agency, I urge you to contact your association attorney first. Right
An
away.
interesting side note, which just reflects the fact that condos and HOAs are just microcosms of our larger societal issues. And there was a whole hour-long presentation at the condo cluster development seminar last week on what do you do if ICE comes to your community, and we all thought, why is this a topic for us? I mean, I don't understand, okay? But apparently there have been instances where ICE has raided certain communities, maybe looking at the landscape crew and doing what ICE does. And I'm not trying to get political or anything like that, but we all were like, wow, that's kind of crazy. But I did learn a few things. And one of the interesting things is relative to subpoenas. And I'm just going to paraphrase real quickly. First of all, if you get this happen, you call your attorney. But apparently there are 2 types of ICE subpoenas. One is an administrative subpoena where they can ask you for records. We want all the records of your employees that are working on the property because we believe they're not, lawful residents or whatever. But there's also a judicial subpoena. And the way the answer to that question was, if it's an administrative subpoena, you do not have to immediately comply. If it's a judicial subpoena, you have to immediately comply. And obviously you're going to talk to your lawyer first, but they said the way to check who signed the subpoena, it'll either be signed by like an ICE administrative official or someone that will say Judge Johnson or Judge Smith. So that was a little tidbit that I guess this has happened and it's a real thing. So obviously if you get raided by ICE, you call your attorney, but there is a difference between the types of subpoenas they use, and they will request official records of your employees that they suspect might be in violation of the law. So crazy how bigger problems in our society reflect right on your small condo or HOA potentially. Never thought it would, but that's the fact. Interesting to me.
Number 4, audited financial statements. The level of financial review that your association has to go through is dependent upon the number of doors, the size of your community. You can only waive these every other year, so you can't do it 2 years in a row. If you have 1,000 parcels, you have to prepare audited financial statements, no matter what your annual revenues are. So I misspoke a moment ago. To some extent, it's dependent upon your annual revenues, but if you're over 1,000 parcels, you have to have audited financial statements no matter what. But it's our opinion that you can still waive that every other year, despite the heightened financial reporting requirement for 1,000 parcels or more. Debit cards, quick and easy, don't use them. Technically, they are allowed, but let's look at why our advice is just do not use them. If you use a debit card for anything that is not a lawful obligation of the association, you're committing a criminal crime of theft. And under B, you see, for purposes of the subsection, the term lawful obligation of the association means an obligation that has been properly pre-approved by the board and is reflected in the meeting minutes or the written budget. Anything that's already pre-approved by the board, reflected in meeting minutes of the budget, I don't know why you'd be using a debit card for it anyway. So again, back to my original answer, just don't use them.
Okay. Number 6, let me jump on this one because I had this happen recently. It's kind of an obscure law that you can, it's a gotcha law, okay? What this law says, and again, this is HOA only, 720 HOA only. It says if an owner requests a detailed accounting of their association financial ledger, then you must provide it to them within 15 business days after receipt of a written request. If you do not provide them this accounting of their ledger, which essentially would be probably provide them their ledger, then any fines that might be listed on that ledger that are unpaid are now waived, okay? So it's kind of a gotcha where they may have significant fines on their accounting ledger. They ask for an accounting, you don't get it to them within 15 business days, fines are gone. So the other thing is they can only ask for this once, I believe, every 90 calendar days. So yeah. So I've had this happen recently once, and someone had read the law, and we got it to them in time. But it is something that you need to be aware of if they ask for an accounting.
Yeah, 3 weeks isn't an incredibly short amount of time, but it's short enough that someone could definitely get you by just requesting it.
The next one is director certification. This was the law. This is the director certification is what I talked about at the beginning. There's 2 parts to it. There's the 90 days of becoming a director. You have to take a course. Formerly, you could sign a certificate saying I've read and understood and I'll follow the law, or you could take the 4-hour certification course. You could do one or the other. Now the law, as of July 1, 2024 for HOA says, and condos too, you must take the course. You have to take the course. You can no longer just sign the certificate. You have to do it within 90 days. The certificate is good for 4 years. And it's a 4-hour course. In addition to that, which I explained, this is the law that we're giving you part of right today. If you're 2,500 or fewer lots in your HOA, you have to take 4 hours of continuing education every year. If you're 2,500 or more, you must take 8 hours. So today's seminar for HOA board members, this will count for 2 hours of your 4-hour requirement. We are offering other courses. I think we might have 1 or 2 available. There will be more available. There are other resources out there to get the extra 2 hours that you need.
Richard, a question we get often is, well, what if we have a board member who just doesn't do this?
Yeah, the statute, and this is condo, HOA, and co-op. If you refuse or fail to take the course or sign the certification, which is still available option for co-op 719 directors, if you don't do it within the prescribed 90-day period, you are suspended from the board until you comply. So you're effectively off the board until you do it. And I have had to write that letter a couple of times and tell them, look, you have not proven that you've taken the course and you're no longer on the board.
Right. They are suspended automatically. The board does not have to meet to suspend them. It doesn't take a letter to suspend them. They are suspended on the 91st day by operation of law until they complete the class, right? Once they take the class, they're back on, right?
Yeah, which is kind of chaotic. I mean, what if I don't take the class for 11 months and somebody replaced me and now I come back and say, well, I finally did it. I'm back on the board. I mean, I think that's just kind of,
right,
messing with people. Number 8, kickbacks. There's a definition of a kickback. I'm not going to define it, but I think we all know what it is. Taking something of value to perform your, statutory obligations. The landscaper says, I'll give you $100 every month if you will make sure I get the landscaping contract for the association. That's a kickback. It's a 3rd-degree felony. Don't do it. If you're charged with a criminal act under the statute, it requires removal from the board. This is different now, and this is probably a good law, and John may have some more on this, but formally, and I always forget the name of the community out in
hammocks.
Hammocks. This came out of the hammocks. The problem with the hammocks, which was that large HOA in Dade County, which was basically a corrupt criminal operation that stayed on the board for years and years and years while they were under investigation. They were charged with all kinds of crimes, yet they were not convicted of those crimes. So all the while they were charged with those crimes, they maintained their status as a board member and they continued to commit the crimes because the legal system, grinds slowly, okay? And they used all the resources available to them to fight back, and they delayed any type of prosecution or conviction for many years and continued to steal money and do bad things. So now the law says if you're charged with these crimes, then you're off the board. And now, presumably, if you're found innocent, you would be back on the board. But now, if you're charged with the crimes by, the federal or state authorities, you're off the board and you cannot continue to potentially commit them. And I think this is probably a good thing.
Yeah, I mean, that's where a lot of these laws are coming from, is the hammocks. Like we were just talking about subpoenas. Well, why do they have to put that in there? Because the hammocks board was refusing to comply with subpoenas and quashing, just doing everything they could to keep their money train through their fraudulent contracts and kickbacks going.
Number 10, they've made some significant changes to the ARC and ARB protocol for HOA boards. Okay, first of all, it says, which you frankly always had to do, you must reasonably and equitably apply and enforce all parcel owner the architectural construction improvement standards. You can't pick and choose. You've got to apply the rules and the restrictions equally and avoid selective enforcement, which you always had to do. The number 2, you now may not enforce or adopt a covenant, rule, or guideline that limits or places requirements on interior structure improvements that are not visible from the parcel's frontage. So some ARC guidelines for HOAs would say things like, if you're going to renovate your kitchen, you need to go through the ARC process. Well, why does how I renovate my kitchen in my single family home affect anybody but me? And that kind of makes sense. Where this doesn't make sense, and again, this is where there's a disconnect between those of us that do this for a living and those of us that sit in ivory towers and draw up laws, which no aspersions to Mr. Trebilcock, who was formerly in the Oklahoma legislature, but we all feel that way sometimes. But where this doesn't make quite sense is think of the townhome community that are attached coach homes or townhomes, where it's a single uniform building and you own a slice of that building, the roof, the interior, everything. That can be an HOA setup. There's very, very common. Well, what I am doing in my single family home, which is attached, can absolutely affect my neighbor who I have an adjoining wall and roof with. So it may be very relevant that I'm renovating my kitchen if I'm going to cut a supply line of power that's going to affect the whole building. But currently, this is what the law says. Secondly, the second one is if you're going to change your AC or HVAC ventilating system and keep it in the same location and it's not visible from the parcel, that doesn't require ARC approval, okay? And we'll get into this in a minute. Some of this goes to whether your documents contain Kaufman language, which I'll explain briefly in a minute. So the fact that these laws and some of the ones we're going to talk about in a minute are here do not absolutely mean they apply to your HOA. It depends on if your HOA pre-existed these laws and whether it contains Kaufman language in your governing documents, which I'll explain greater in a minute. The next one here is very good, I think. Number 11. This says, and I've had a couple of associations that I've had to help modify their ARC denial letter. When you deny an ARC application, they submit something, I want to do X, Y, and Z, and you deny it. You now must, in writing to the parcel owner, state with specificity the rule or covenant on which the committee is relied on when denying the request and the specific aspect or part of the proposed improvement that does not conform. You can no longer just say, we reviewed your application and it's denied. If you must say, for example, we reviewed your application and Rule 5.5 of the ARC guidelines list the colors that you can paint your home. You're asking us to paint your home purple. Purple is not one of the approved colors according to the rule, therefore denied, okay? That would be an example of what I'm talking about. Or if the overall, proposal is in compliance, but a part of it is not, then you have to state what part of the proposal is not approved and why. So you need to be very specific as to why you're denying the ARC application, okay? Number 12 is also important. For HOAs now, as of July 1, 2024, you have to adopt hurricane protection standards, okay? Meaning what type of shutters they can put up, what type of hurricane protection they can use. Is it shutters? Is it hurricane rated windows and doors? But most importantly, where this is coming into play is this last paragraph, okay? Hurricane protection, the term as used in 720, now includes roof systems, okay? And I've just had this yesterday with another community. What this means is if let's say, for example, your community has an ARC standard that says roofs have to be concrete or clay barrel tile. That's the only type of roof you can have. And you have not adopted a hurricane rated roof system. So I come to you and say, I want to put in old Florida style metal flat roofing system that is not in compliance with your ARC standards, but it meets the Florida Hurricane Code protection guidelines. If you have not adopted a hurricane protection protocol or guidelines for your barrel tile, concrete, or clay tile roofs, I am allowed to put in that as hurricane protection, that roof that is not in compliance with your ARC standards. So what this means is if your governing documents or your ARC guidelines limit the types of roofs, you now have to actually identify that type of roof that is code compliant with the current hurricane code requirements is the only type of roof hurricane protection system you can use, so that you don't have people using this as a loophole to get around wanting other types of roofs. It sounds a little far-fetched, but the roofing companies, and I've seen their websites, and this is an example of where ChatGTP is dead flat wrong. You ask it, or at least the last time I asked it, can the HOA stop me from putting in a metal flat roof if my documents don't allow for it? And when I did that, it said, no, under this new law, they cannot prevent you from doing that. That's incorrect. If you've adopted the current hurricane roof systems that you do allow as your hurricane roof protection system, and it doesn't include a flat metal roof, you absolutely can prevent it. So again, don't believe ChatGTP verbatim. But this is important because people are aware of it, and roofing companies are promoting it as you can get around your roof requirements using this law, which again, long-winded, you can unless you've adopted roof protection system code compliance that are in compliance with your guidelines. Number 13, items in the backyard. In 2023, they made a law that said, if your documents prohibit certain items from being placed in the backyard, an example would be a shed. It's very common to have HOA documents that say no freestanding sheds are allowed in the backyards of homes or anywhere on the lot. The law in 2023 was changed to say, if you cannot see the shed in the backyard from an adjoining parcel or from the common area or from the front of the street, any prohibitions in your documents that prohibit things in the backyard are inapplicable and you can't enforce them. So what this law did is they added more things to it. If your documents say no vegetable gardens on the lot, if the vegetable garden is in the backyard and you can't see the vegetable garden from an adjoining lot, let's say you have a fence all the way around your backyard, you can't see it from the adjoining lot, you can't see it from the front of the lot, and you can't see it from behind the lot in the common area. Maybe the person across the lake can't see into your backyard. This law says I can put anything I want in my backyard as long as it's not visible. Now, I'm not want to get too long-winded. This is the portion of, does your document contain Kaufman language? And you need to talk to your lawyer about whether these prohibitions of putting things in your backyard, and there's also a prohibition against You can't prohibit commercial vehicles or trucks in the driveway law that was also put in place in 23 or 24. Do those laws retroactively cancel your pre-existing prohibitions on the same item? The answer is not a clear-cut yes or no. It depends on if your documents contain Kaufman language, which effectively is a court case that says, do your documents incorporate future changes made to the law, or do they not incorporate them and you only apply the law at the time the declaration was recorded? That's all dependent on the Kaufman language. Talk to your lawyer about whether your documents contain Kaufman language, because it's a critical question to answer to determine if these laws about commercial vehicles and things in the backyard apply to you or not. If your lawyer doesn't know what Kaufman language is, an experienced condo HOA lawyer is very familiar with that case, and you need to make sure your lawyer understands that as well. Let's see, fines and suspension procedures. Okay, they changed a lot here that has caused a lot of uncertainty. Effectively what they did, and again, there's a fine and suspension procedure for condos and co-ops, which is the same, and it was the same for HOAs. This is an example of a law that was changed for HOAs, but does not apply to condos and co-ops. So your fine and suspension procedures and exceptions are the same as they always were for 718 condos, 719 co-ops, but for 720, we now have these changes to suspending and fining. Number one, it clarifies that the hearing can be held by telephone or other electronic means. You can have a Zoom fining committee hearing, etc. Within 7 days of the hearing, the committee must now send a written notice of the decision of what happened at the hearing. The notice must include what the person can do to fulfill the suspension or remove the fine if possible. And here's the big one. If the violation has been cured before the committee hearing or in a manner specified in the original notice of the hearing, the fine or suspension cannot be imposed. So this means, for example, we tell you, you need to paint your house because it's not an approved color. And for every day that you don't paint your house, there's going to be $100 a day fine until you paint your house the approved color. And oh, by the way, there's a fine or suspension committee hearing in 14 days. The fine or suspension committee hearing is effectively an appeal of what the board's decision was. And the fine or suspension committee hearing can say, no, we don't agree, or yes, we do agree. So let's say before the fine or suspension committee hearing, I paint my house, okay? And so I walk into the fine or suspension committee hearing and say, well, before we get started, here's a picture of my house from this morning. It's now painted the approved color. What this means is no fine or suspension. It's gone. You corrected the violation before the committee had a chance to approve or deny what the board did. And that sounds, okay, the real impetus behind this is we want you to correct the violation. We don't want you to impose a fine or suspension. Our ultimate goal is to get you to make the correction, which sounds good. The problem is every violation correctable? If I ran over the stop sign, how do I correct not running over the stop sign before the hearing? I can't unrun over the stop sign. Number two, and we've had this, what about the person, and there's always one, that wants to play games? And I had this recently where you can't leave your basketball goal out overnight. Your portable basketball goal in your driveway has to be put away every night. So I leave it out overnight. I get a suspension or fining committee hearing notice in 14 days. I walk into the hearing and I say, I've moved my basketball goal in last night, so no fine or suspension. Thank you, goodbye. As soon as I get home, I pull my basketball goal out and I set it up again and I leave it out overnight again. And I get another fine. And then 14 days later, I walk in and say, haha, guys, I just moved it in last night. So the person is playing a game where they're violating it, but correcting it before the hearing, and violating it and correcting it before the hearing. What do you do? And I don't have a perfect solution. I don't know if John does. But I think if you have a regular pattern of this, where you can show 3 or 4 or 5 examples of doing this and correcting it and just doing it again, I think a court ultimately would probably not uphold that as a way to use a loophole or game the system. but you need to talk to your own legal counsel about that. I don't know if John or Leanne have any thoughts or have experienced this.
My thought is that, curable. If it's a violation in a moment of time, I don't know that that can be curable. It already happened. It existed. I think the curable, I would argue, the example you used of the garage door. Obviously that's not a repeatable offense. It's cured. But if you are leaving your dog waste out and someone else picks it up for you, is that cured? I think that's the violation happened. And I think a court would probably look at it that way, but I don't think there's any case law on this yet.
Not yet. My only thought was, and I don't know if this is a perfect solution, but I've advised some clients, make the board impose the fine or suspension prospectively, not what's existing today or what happened yesterday, but say for every day in the future that you do X, there's $100 a day fine. For every day in the future. You haven't done it yet. We're not fining you for an existing violation. We're prospectively fining you. Then I think you could argue that's not curable because the fine was for every time you do it. Now, is that perfect? Will it really work? Has it been tested in court? No, but I have thought that maybe that's a way to say that you can't cure it because we warned you in advance the fine's coming if you do it again and you did it again. I don't know what your thoughts are on that.
I think Leanne may have something to.
Yeah, I was just going to chime in and say, that's the approach that I've taken as well. But like John said, these issues have not been tested in a court. So we don't know what a judge would say about it. But I think that there are many creative ways to try to get out of the statute. So talk to your attorney and let them advise you directly, depending on the situation. But we don't know for sure whether these things will stand up in court. I have an important question that I was interrupting with it, which is, can the members of the fining committee be board members? And
no.
Yeah, absolutely not. They also cannot be, a spouse, a parent, a child, brother, a sister of a board member.
Or work for the association.
Yeah, the intent is very clear that your fining committee has to be very impartial and not associated with the board at all. And that's how we ensure that they are fit to review whatever fine or suspension.
I also had a question recently where there was a violations committee which identified violations and reported them to the board. Then the board imposes the fine or suspension, and the same people that are on the violation reporting committee were now on the fining suspension appeal committee. And I said, no, you can't act as, judge and jury. So I do not recommend, you cannot be the one that reported the violation as the committee and then say, we're going to be the person to decide if what the board did. I think it's not expressly prohibited, but I think that goes against the intent of what is supposed to be an impartial committee to give a fresh look at what the board imposed to determine if they agree with it or not. I don't know what you guys feel.
Remember, underlying all of this is the concept of due process. This is all to provide due process. And I can't imagine any judge finding that the people who found and decided there was a violation ultimately being the arbiters of whether or not a fine was correct, being due process. I mean, it goes.
Yeah, that's like the state attorney charging you with the fine or start charging with the crime and then sitting in the jury box to determine if you committed the crime. That's not going to work. They've made a couple of interesting exceptions to fining and suspensions additionally. Now, if you have rules about leaving your garbage can out after 6 p.m. or bring it in before 6 a.m. or whatever it is, there's a 24-hour before and after grace period. So whatever your rule is for leaving your garbage can out or putting it out or bringing it in, you get a 24-hour grace period. The interesting thing is that the law talks about leaving it on the curb or at the end of the driveway. So what if I put it in the middle of my driveway and I leave it out too long? Do I get the 24-hour grace period? It's not at the curb. It's not at the end of the driveway. It's in the middle of the driveway. So again, words matter, and clever lawyers are paid and experienced to get around them. But effectively, there's a 24-hour grace period.
Well, another fine point there, lawyers reading the words literally, that says you can't fine or impose a suspension. It doesn't say that you can't go to court and get an injunction against a repeat offender. You just can't find them.
Right. The next one is leaving your holiday decorations out past the bring it in time. You get a 1 week grace period. So if your documents say you must take down your holiday decorations by January 15th, I now have until January 21st. I get a 1 week extension to do it. The interesting thing is, again, they don't define what quote unquote holiday is. Presumably, most of us, but not all of us, would define that as probably the holiday Christmas period, whatever you want to call it. December, through January is traditional holiday, but July 4th is a holiday. Coming up on Tuesday, Veterans Day is a holiday. I might decorate for Veterans Day. You could conceivably probably decorate year round, basing it on there's 10 or 11 federal holidays. So you could probably keep your decorations up a long, long time by just piggybacking on the next holiday. And it doesn't necessarily even say it has to be a federal holiday. It could be, I personally like to celebrate Arbor Day because I like trees. So I'm going to put up my decorations. Again, we're being facetious, but this is where the laws, they sound good on paper, but people like to play games and parse the language, and you can do all kinds of things if you're clever. I'll let John take the voting fraud.
It's bad. Don't do it. Again, some of this was probably arguably already a crime before they put it in 720, but because of the Hammocks Association that we referenced earlier, they fleshed it out, made it more clear. Don't commit crimes just to sit on the board that you're not getting paid for all the service that you do for your community anyway. Now the big one, the complicated one, Richard, the work vehicles and trucks. This is the biggest controversy coming out of the 2024 legislation as far as HOAs, in my opinion, as far as the calls that we get. Would you agree with that?
Oh, yeah. Everybody is aware of the law, but again, this goes back to the Kaufman language. This may or may not apply to you. You have to talk to your lawyer about Kaufman language, but if it does apply to you and your documents say you can't have trucks or commercial vehicles in the driveway, and you do have Kaufman language in your documents, then this law applies to you, and you can no longer prohibit trucks or commercial vehicles in the driveway, or what they call a work vehicle, which God knows I drive the Oscar Mayer Wienermobile to work. So now it could be in my driveway.
Well, and something to clarify here, because people will read this and it says, commercial vehicles under this statute are not decided because of the logo or like Richard's hot dog car. It's by the number of axles. So basically these are 3-axle, semi trucks that are defined as commercial vehicles that you can still ban. But that's not how most of your declarations, if this is describe a commercial vehicle, it's, logoed vehicles. And for those of you in the condo world that are still here, this does not apply to you. I've had that come up, or I thought we couldn't ban pickups in the condominium anymore. But this is an HOA statute only for now.
Another important part here is bullet point 2. It now says HOA documents may not preclude a property owner from using whatever contractor they want, who may or may not be on the HOA board's approved contractor list. So you cannot dictate the contractor I use to work on my single family home. Okay, I get that. The next part also says the association may not require the contractor or worker to present or prove possession of a professional or occupational license to be allowed entry to work on the owner's private parcel. So I can use an unlicensed roofer to work on my roof, and you can't require them to prove they're a licensed roofer, which again, single family home, not attached to anybody else. If I want to use an unlicensed contractor, who am I harming? I'm harming myself, okay? But what if I'm in an HOA 720 attached coach home or villa community where there's 8 attached units and we all share a roof, and I own 1/8 of the roof, which is the slice of the roof that's over my home. I'm now allowed to use an unlicensed contractor to work on that roof, which can have significant impact on the whole roof system but you can't require me to have a licensed contractor. Sounds like a good law when it's a traditional single-family home, but it makes no sense when it's an HOA 720 controlled community that have attached homes. So
Well, Richard, do you
again,
think that you could make them present proof of insurance?
yes, it doesn't say insurance. So you could require insurance, but you can't require them to prove they have a contractor license, which, you
Yeah.
know,
Surely they wouldn't have the insurance doing work for which they don't have a license, so.
right. So maybe that's the way
Maybe a
around it. 18 is about fuel sources used in the HOA. If there's a legal supplier of a particular type of fuel source in your area, you cannot prohibit people from utilizing that fuel source. So I guess theoretically, if my house, I want to put in gas stoves and my house, my community doesn't have gas, and I can get gas lines there and I can use it, I would be allowed to do it. Theoretically, is what this says. Interest, it just clarifies you can't charge, you can't charge compounded interest on late assessments. It's just simple interest. We've always advised of that. Now it's the law. The term law enforcement vehicles, which cannot be prohibited from being parked in the driveway from a law from several years ago, it's now replaced with first responder vehicles, and there's a list of what those are. So even if you prohibit certain vehicles in the driveway, you have to be allowed to allow first responder vehicles. This next law is already passed. As of October 1, 2024, you were required to send a copy of the governing documents to all the owners, or I believe tell them they were made available if they wanted them. So that law is already passed. MARTA revitalization, it's just a different department reviews these types of filings than formally. Timeshares, I'm not going to go into a great deal of timeshares. If you're in a timeshare, take a look at this. If you have questions, you can ask us questions. Mobile home subdivisions under Chapter 720, the flood disclosures we talked about are now required for a Chapter 723 mobile home subdivision, which some of you may be in or manage. The next part I'll let John, this applies to everybody. This is the new CAM managers licensing, not new, but changes to the manager licensing rules. And this would apply to HOAs, condos, and co-ops who are all managed probably by licensed Florida CAMs.
Right. So if you are a manager or the manager of your association has their license revoked by the state, they cannot have any direct or indirect ownership of or be an employee or have anything to do with a community association management firm for a decade, for 10 years. My reading of this, the strict reading, they can't even be like a custodian, a janitor for the management company for 10 years. So it's a severe penalty. Online disclosures for managers. A manager and management company, they have a portal with the state, a list that they have to keep up to date. And here's another example, I think, of where the legislature made what may be a reasonable requirement, but they don't make it clear what they mean. A manager has to input every community association for which he or she is the designated on-site CAM. To most of us, designated on-site means you work in one community full-time, and that's the only community you serve. I think what they mean is if you're a portfolio, you list each of the communities that you are the main CAM for, not just a floater, for example. And you have to update this within 30 days of any change. Management companies have to identify all the managers they employ. And again, if a manager has his or her license suspended, the department must give written notice to each of the community associations that manager provided services for. Number 3, makes it clear what should have been self-evident, but I think this actually helps managers. It makes it clear that a manager or management company may not knowingly perform any act directed by the community association if such act violates state or federal law. In the past, I know some attorneys might have taken the tact of, if they tell you to do something, is contrary to statute, make a note in the file to protect yourselves. Now it makes it very clear, you may not do this, and the CAM can point to to this provision in the statute to protect themselves. The question that managers didn't ask me, well, what if they insist? At that point, I think you maybe have to consider terminating a board who is directing you to break the law. Management disclosure, number 4. Each contract between a community association and a CAM or management firm has to include the following written statement in at least 12-point type on the contract that, quote, the community association manager shall abide by all professional standards and record-keeping requirements imposed pursuant to Florida statutes. Evidently, there were some management companies, I haven't personally seen this, but they were essentially trying to contract away their responsibilities to manage your official records or other statutory requirements. This makes it clear that they cannot do that. They cannot waive or limit their requirements under the statute. Number 5, if a manager or management firm proposes to engage in any activity on behalf of the association that's a conflict of interest at the level of $2,500, the notice for the board meeting at which the proposed activity will be considered must basically, list out what they're doing, what the conflict is, copy of the contract. I've seen some management companies try to comply with this just by saying, well, they have a list on their website and that's their conflicts. But that doesn't address the fact that at the meeting where the contract has to be signed, these requirements come into play. So just be aware of that. Official investigation is the definition of that has been broadened to include any investigation by the Division of Condominiums, DBPR. This pertains to when a board member is suspended while under official investigation. So if the division is looking into you, you're gonna be suspended. So it's not just the state attorney or other law enforcement. It's also an investigation by the DBPR. Richard, do you want to talk about your favorite one here, dangerous dogs?
Yeah, this was a law that says if a dog owner has knowledge of the dog's dangerous propensities, the owner must securely confine the dog in a proper enclosure. I'm sure the dog owner will deny they have knowledge of the dog's dangerous propensities, but they basically beefed up the dangerous dog law. A dog that has killed a person or has bitten a person and left a bite mark that scores 5 or higher on the Dunbar bite scale. I never knew there was a Dunbar bite scale for dogs, or maybe it just doesn't apply to dogs. It applies to anything that bites, but there is a scale. But if they exceed 5 or higher on that scale, they must be immediately confiscated by animal control. So I think the point here, and why does this pertain to community associations? Because, it's not uncommon that you get the owner complaining about the other owner's dog that bit them or bit their dog. And I've had situations where it's been very, very significant. This gives you some guidelines as to what can be done as far as removing the dog. If the dog is classified as a dangerous dog, it has to have a microchip implanted in it, identifying it. And if they remove the microchip, it's a 3rd-degree felony. If it's classified as a dangerous dog, the owner must now maintain insurance of at least $100,000 to cover damage caused by the dog. And a dangerous dog that has killed a person or left a bite mark of 5 or greater must be euthanized. So, and it's a crime or to interfere with animal control. So, this just puts some more, requirements into that could help a board potentially. The owner with the dog that everybody believes is a dangerous dog always, I'm a dog owner too, or, I understand the love of our pets, but sometimes the reality is your dog is dangerous and you can't control it. And while you may feel others are being harsh, this would give you some ways to better push back on having the dog muzzled or controlled better.
Right. These last 2, 8 and 9, every year the division throws some things into the required syllabi. that association attorneys and others providing these courses do. Number 8 is changes to the Administrative Procedure Act. So remember earlier we said the division is going to have to promulgate rules to further flesh out some of these new statutes. Well, this is dealing with the rulemaking process. I don't think we need to go into a lot of detail here. You can read the process if it's something that you want to involve yourself in. This is really an entire semester in law school over the APA and administrative law. And it's if any of you have insomnia, I would recommend reading some of those textbooks. The very last one, number 9, is another one that you may wonder what does this have to do with association law? Education and correctional facilities. It makes it clear that inmates who successfully complete classes to meet necessary curriculum for professional licensure receive credit towards the DBPR licensure requirements. Well, if you remember, when we started this part about association management, we mentioned that if you lose your license, you can't work in the field for 10 years. So maybe the way that they tied this in is if a manager is breaking the law and they go to prison and they decide to get their CAM license back, this is their way back into the field after they've done their time. But I really honestly don't know what this has to do with association law, but they said we had to include it, so there it is. So that leaves us with time for questions now. That's our legal update. Now let's turn to the hot topics Leanne's been monitoring for us.
All right, we have I've tried to answer a lot of questions as we're going, and I have you should be able to see them, but we do have a bunch of other questions here. Can you guys see them, Richard and John?
Yeah, I saw the number climbing in the last year.
Yeah.
So
one of the ones that I like is what if the dog is a service animal? And I assume that was relating to the dangerous dog discussion. But yeah,
service animals, certain requirements don't apply to them, but a service animal that is considered a dangerous dog, I don't believe the service animal exception is going to prevent the implementation of the dangerous dog laws.
No, almost certainly if it is a dangerous dog, it isn't a real service animal anyway, because those are highly trained animals.
Yeah. My position is being that the association is not required to allow a dangerous dog. I mean, the service animal exception is under the Fair Housing Act, allowing reasonable accommodations. Is it reasonable to force an association to have a dangerous dog as a service animal on the property? My position has been no.
Well, remember, a service animal is different than an emotional support animal. So a service animal probably this would happen, but an emotional support animal, you could run into a dog that's a nuisance or a dangerous dog. That's
not a bad question. That's an interesting topic. The emotional support animals I see a lot of, and nothing against people who have these dogs, are pit bulls. And they'll have them qualified as an emotional support animal, but I believe nobody will deny that they are, under the SPCA, they are considered a dangerous breed. That doesn't make them illegal or not allowed. But I suppose you could ask on the question, even though you're qualifying this as an emotional support animal, has it been designated a dangerous dog under anything? I think that's a relevant question to ask. I don't want you to do it without talking to your attorney, but theoretically they could answer the question, yes, that legally it's been clear, it's chipped, I have the insurance, all of that. Could you then prohibit it? That's a very interesting legal question. Don't take my advice and do it. Talk to your attorney.
I'm going to share the email for CAMS one more time. It is also in the chat box, so please go look for it, but it is webinar@gadclaw.com. So if you're a community association manager, please send an email there with your name and your CAM license number so that we can get you your credits.
Here's a question for condominiums. If the manager is an employee, are they required to be licensed if the employee earns more than $100,000 annually? The licensure requirement isn't tied to the salary. It's to the activities that they are doing. If they're just doing ministerial, data entry or something, answering phones, that may not require a license. If they're doing property management as defined in the statute, then yes, but it's not tied
Yeah.
to how
Yeah,
much
the
money.
requirement is if a manager is being paid and they're managing more than 10 units, or the budget, I believe, is greater than $100,000, they must contain a CAM license. But as John said, there's a list of what constitutes management. I've had this come up time and time and time again. Oh, they don't manage. They're just administrative. Well, when you really dig into what they're doing, they are managing. They are preparing notices of meetings. They are conducting meetings. They are preparing the budget to propose to the board. They're doing all kinds of things. And managing, getting paid to manage without a CAM license when you're required to have one is illegal. And the association can get in trouble for allowing it to happen. So don't try to skirt those laws, because if problems come up and they find out that it's going on, and then the person goes and wants to get a CAM license, one of the things that they will ding them on is you were managing without a license before. We're not going to give you a license. So don't tell me that the person is just sweeping the floors when I know they're in the office every day actually managing, and you're doing that. I've seen that happen a lot. So
Yeah.
it's easy to fall into management when you think you're not doing it.
Here's another. What if the board doesn't use a finding committee, but just forwards to a legal department? And that's fine. Look, every community is different, and the dynamics in every community is different. So what may be appropriate, a finding committee may be effective for this association. And in another one, they may not even be able to put a finding committee together, because while some people enjoy passing judgment on their neighbors, other people don't want to. So you cannot fine if you don't have a finding committee. And for some things, a fine, it just isn't going to bring somebody into compliance, which is ultimately the goal. Remember, finding is never a money-making prospect. It's meant to bring people into compliance with your covenants. And sometimes, there may be other actions that your association council can do that a finding committee couldn't.
Yeah, fining is really just one tool in your toolbox. Fining is a tool, suspension is a tool. There are many other tools to compel compliance.
There was a question we get a lot earlier, I noticed earlier, which was, what about, so you have to have an affidavit acknowledging that you've had your SIRS done. What if we did it before July 1st of this year? My opinion is no. If you got your SIRS done before July 1st, you don't need to fill out that affidavit. The law became effective July 1st. So it would be SIRS that were received after July 1st, 2025.
We have so many comments about the materials. Again, the materials are both in the chat box and they're also in the resources tab. I believe if your Zoom settings are not enabled or allowed to enable file transfers, you might not see the materials. If for some reason you still cannot get them, please email them, or you can email me or email the firm and we'll be happy to get them to you.
And I believe the legal updates for 24 and 25 are on our website. I know the 25 is, and 24 should be.
That's
And
right. You can
probably
likely get them on the
23
website
as
too.
well.
Can we require soundproofing on our condo floors when replacing flooring? That's going to be document specific. It would need to be in your governing documents. So that's one I would discuss with your counsel and look at your documents.
But if appropriately drafted, yes, you could do that.
Yeah,
Yeah.
that's pretty common as for, second floor units and higher. There's a question about removal from the board. Is it for condo 718 or 720? I don't know if we discussed recalls, but yeah, you could be removed from the board if you're in 718 and 720.
Majority vote of the total voting interest in each case.
They may have been asking about being removed if you didn't comply with your education, but
Okay.
yes, that would apply to
all three.
all of the above.
What do you guys think about the timing of the continuing education? This person said they believe it was for the period July 1 to June 30th each year, which I think, is the date that the statute became effective.
Well, that's been the problem. They put this law for continuing education in place in July 1 of 24. and they said you have to get your curriculum approved. And it took literally a year or more for them to start approving curriculum. Some lawyers got it done sooner, some later. So it's really was kind of in chaos. But now I think they've got it straightened out. I don't think you're going to get dinged for it, but I think from this day forward, I think at least every year, this is for 25. In 26, you're going to have to make sure you get some more. I don't know that it runs from July to July. That would be kind of hard to keep track of.
Yeah, I've just treated it, the statute says annually, so, do one each year.
Hopefully they just change it and clean it up.
That would be great.
And get rid of the
Here-
8
here-
hours
here-
for big HOAs. I don't understand that.
Right, that's crazy. With the new requirement for board members to be physically present, is there any grace period for compliance, as we have a meeting next month and the board wasn't aware of this change? The answer is no. The law became effective July 1st. A quorum of the board needs to be at the annual meeting. But again, it doesn't lay out any penalties. I would presume that you should not conduct business if the quorum is not there. But the only business that has to be done is the election. And again, in a condominium, if 20% of the voters vote, the election is valid. And any other business that you might have had, you can do in a different special meeting.
Going back to emailing your election ballot, we have a comment that says, well, then wouldn't you know who's voting for who? Isn't that a problem to be able to see who's winning the election?
That yes,
Yeah.
it's not a
But
secret
there's a
ballot.
big disclaimer that has to be on there. I know I'm waiving my secret ballot so everybody can know how I voted.
And that's a good point. I haven't looked at the law very closely, but I don't believe you're in a condo election. You're not allowed to open the ballots until the day, at the meeting in the presence of the owners. But if you've emailed your ballot back, do you have to not look at the attached ballot? I don't know how. See,
I don't
again,
know
the
how
devil's.
they have to, because they have to
Yeah.
monitor and make sure that they're coming in and check the
Yeah.
spam folder.
There's a
and
lot
all
of good
that.
questions that are unanswered, and that's why I don't think it's a good idea to try to figure it out as a first timer.
I mean, I think most managers are looking at them because I've already heard that this election is close based on the emailed ballots. So
Oh, there you go. And can the board have an executive meeting to discuss sensitive items without inviting the owners? Only in two circumstances: if you're discussing personnel matters or if you're having a meeting with the association's attorney to discuss proposed or pending litigation. Otherwise, if it's a sensitive matter, you still have to have an open board meeting. We probably got about 2 more minutes here for questions.
yeah, and there are a lot of good questions here. Like Leanne says, we all write articles for various newspapers, and we'll take a lot of these and probably use them as material. But we're not. You don't get any kind of kickback for the good questions that you're asking that we're going to use. I have a 5-member board and only one has a certificate of completion. What can I do? They're supposed to pass the budget next week, but technically only one should be active.
You have 4 vacancies on the board, and that one person should appoint 4 more people that are compliant.
Yeah, until they take the class.
Right.
They're suspended, and although important point there, the statute does say that an action by a board where someone who has been suspended but casted a vote is not automatically invalid.
Or send them to our website. We have the 4-hour certification course. They can take it in 4
they
hours.
have time.
I think we get this comment during every webinar, regardless of the content, which is pretty much, for official records indicating delinquencies, are we including the owner's names on there? Yes, we are. That's not confidential in any way. So you are allowed to see if your neighbors are delinquent.
Right. Although the one thing you should not do is send out what I call a scofflaw list in order to try to shame and embarrass owners. So if it's in a budget package or report with another purpose, that's perfectly fine. It's not confidential. but you can't say, send out a list, Richard and Leanne are still late, they won't pay their assessments. Everybody, shame them at happy hour Friday night.
Mhm.
What's noon, Leanne? Do you think we should wrap it up? Any closing comments from you two?
Personally, I get more and more frustrated every year as these laws roll out, that we don't know what they mean. I'm sure you guys feel the same way. Let's see what next year brings, but that's what we have for 2025.
Yeah, I'll
there's
tell
already
you
lots of
one.
ideas popping up there in Tallahassee about what they can do for you.
One more
this
quick
area.
story from the condo committee. I was talking to a person that has been going longer than I have. When he was lamenting exactly this, every year these laws change. He said back in the day, they would do like a 5-year plan. They would start one big community association bill and they'd work on it for 3 or 4 years. And they would have one vehicle. And then every 5 years, they would kind of do a large revision bill. And that gave people time to vet the changes, to think about them longer, not rush to them. And he said that worked much better. Now, every year, there are changes, and he was exactly bemoaning the fact that you figured out last year and next year they change it back, and it's become much more chaotic and hard to keep control of. And I think going back to the slower process, but John will tell you, the the legislator wants to take home something to his constituents. You asked me to do this, I got it done. I'm a champion, and there's that dynamic.
Yeah, and the confusion where the 720 and 718 don't track, it's because they let one lawmaker run with the condo bill and another lawmaker, maybe in the other chamber, run with the HOA bill, and they don't always make it through the finish line. So that's kind of how this mismatch happens.
And just in closing, I'll mention again the email address. First of all, if you're a director, you're going to receive your certificate within 24 hours by email. If you are a community association manager, we need you to email us at webinar@GADC Law. Include your name and your CAM license number, and we will get you your credits.
Yeah.
And I
We
think that
appreciate
closes
you all
up.
taking the time to listen to us.
Yes, thank you very much for attending. Enjoy the rest of the week.
Bye-bye.
Bye.